Hello, everyone. Good morning, afternoon, evening, depending on where you are and depending also if you are listening to this live or to the recording. My name is Stefano Zanero. I am one of the chairs of the IEEE Digital Privacy Initiative. That is one of the initiatives of IEEE Future Directions. And I'm very pleased to welcome you to today's roundtable discussion on the digital privacy expectations in the era of digital health. The event is organized jointly by IEEE Future Directions and by the IEEE Digital Privacy Initiative. Just a few logistic reminder before starting. The event is being recorded and it will be available on demand in a future time. The slides will not be shared, but you can access them through the recording. If you have any audio or visual issue, please use the chat that you can access through Zoom. We will be monitoring that in order to be able to try to assist you and try to get the best experience possible for everyone. If instead you want to give us either a question or a comment that is related to the content, so something that we can maybe read out aloud and discuss with our panelists, use the Q&A feature instead. Q&A feature, questions and remarks, chat feature for any help, any issues with the webinar itself. At the end of the webinar, we will try to have a little bit of lively debate, but please be posting questions in the Q&A box even before that time, because if we receive any question ahead of time, which is good during the flow of our discussion, I will be sharing that with our wonderful panelists, which it is now my pleasure to introduce. We have with us Agata Ferretti. Dr. Ferretti is a postdoc researcher at the Health Ethics and Policy Lab of ETH Zurich. Dr. Ferretti's work is on ethics, and it aims to address the ethical and the normative questions of digital health. Her interests go and include ethical uses of artificial intelligence and mobile technologies for health, the governance of big data, and the ethical oversight of biomedical research. At the moment, Agata is exploring the ethical and the policy issues related to the use of digital technologies for youth health promotion in low and middle income settings. So her ethics research is splendidly in line with our panel subject today. Agata, thank you very much for joining us today. I will give you the floor. I will give you the floor in a moment. Thank you very much. Then we have Jenifer Shahan McIntosh. Jenifer is a data privacy, security, and risk attorney. She advises clients on the legal, operational, and reputational risks related to data use, the contractual obligations, and intellectual property assets. She has worked with clients that have been setting up privacy by design. She's worked on security frameworks, operational resiliency, and her expertise, of course, she's US-based, but she has worked extensively on GDPR issues. So she will be able to give us a little bit of perspective from both sides of the Atlantic. As you know, IEEE is an international organization. We cover and strive to cover the entire world. So we will be trying to look at these issues from multiple points of view in this webinar and in our other webinars to follow. Jenifer's expertise includes compliance, product design, mergers and acquisition due diligence, the health and wellness services, clinical trials privacy, and tech transactions resiliency. Jenifer, thank you very much for joining us today, and I really look forward to your thoughts on this super important subject. And last but not least, Berrin Serdar. Dr. Serdar is a co-founder and managing director of Cloud Privacy Labs, which is a technology company focusing on harmonization and exchange of information between different systems in a privacy sensitive setting. And so she is wonderfully positioned to be the technical expert of today's panel. She is trained as a medical doctor, and she received her PhD in environmental health sciences and epidemiology. So I'm really embarrassed. I feel humbled by all these achievements altogether. She's a real doctor. She's a doctor that actually helps people, not like the other doctors with me on the panel today. Prior to her current role, she was a faculty member of the Colorado School of Public Health, where she directed multiple population-based research projects. Berrin, thank you very much for joining us today. So I would like to ask our panelists to start by introducing themselves better than what I could do based on their biography, but most importantly, to give us the perspective from their own research, from their organizations, on the subject of how the modernization and digitalization of health impacts with digital privacy from an ethical, legal, and technical standpoint. I would start with the ethical standpoint. Please, Agata, share with us your point of view.
Thank you very much. Thank you for the kind invitation. It's a pleasure and an honor to be here with you online, with all of you also watching this maybe in a few days or a few months to come. So yeah, I'm Agata Ferretti. I'm a postdoctoral researcher at ETH Zurich at the Health Ethics and Policy Lab. And we, as a group and myself in my research over the years, we focus on addressing ethical and policy issues emerging by the new technology development in the field of medicine. In particular, I'm sure you realize like technology is always with us. Even when we sleep, some devices are awake and collect information about us, and all this technological advancement didn't spare any field, and of course the medical one has been heavily affected by these technological changes, right? And so our goal as a group is really to reflect on what could be the implications of these changes at the level of individuals, of course, but also of collective implications, so for groups and societal implications. And in terms of privacy, particularly, I would like to start highlighting maybe more a definitional definition aspect. Often we talk about privacy, but what we mean in many contexts is actually data security. And I see it often because I work at the Federal Institute of Technology. A lot of my students are engineers, computer scientists, roboticists, and they're often heavily focused on this part, right, of like how to make system very robust and prevent, for example, hacks attacks or data leakage, of course. And this is absolutely important. But I also often highlight and discuss with them the importance of looking at privacy really as something more than only data security. Privacy, I think, has to do and refers more to the user expectations and the type of data uses that we make of the data. And so I would like just to remind you of this linguistic distinction that is though also a distinction in reality that we have to keep in mind. Another aspect that I think it's really important to highlight in the discourse about privacy, in particular in digital health, is that when we talk about privacy and we think about user expectations, we think about a user, right? So there are people that use the technologies, and these users are often left, aside. They're not engaged in the process of developing technologies. And I think this is problematic if we think about building privacy strong technologies, if we don't think about involving the end users in the process from the beginning. And so I think it's really important to, from the beginning, in the technology development process, to transparently communicate to the user and to the general public how the data that are collected via technologies are going to be not just harnessed, but also used and potentially shared and stored. And only through this process, actually, we can talk about properly integrated privacy mechanism in the technology development. And then finally, I would say it's important also to engage people in the sense of like having them participating and let them express whether or not they want to be part of certain data collections or data uses. And this is possible only if they are correctly informed, transparently informed about these technology uses, and allow them to actually, opting out eventually. And so I would like to highlight that I believe that these, uses of ticking boxes to acquire people agreement might not be the best solution to actually have them expressing whether or not they want to participate or they want their data used in certain ways. So these are just some points that I want to raise, and I'm looking forward to the conversation forward. Thank you.
Thank you very much, Agata. These are super important points, and they are the reason why I wanted to start with the ethical standpoint, because as engineers, as privacy experts, that's the point, that's the starting point of many of our consideration. Of course, the law is another point that we need to take into careful account in this area. Jenifer, would you mind sharing with us your opening thoughts on the crossing of digital privacy and health and the legal implications of that?
Sure. Well, health, at least in the United States, the healthcare data has always been, or has within the last 40 years been important. HIPAA was drafted. I view that as the grandfather of all privacy laws. GDPR harkens back to a lot of the requirements of HIPAA, and HIPAA, when you compare it against GDPR and the articles of that legislation in Europe, there's basically the same premise, and that is notice, adequate notice, accessibility to patients' data, to data subjects' data, and then the security of that data. And then there's the ethical use. What I call the don't be a jerk part of all the laws is where you don't have undisclosed secondary use, you don't do manipulative things with the data, and you don't hide the ball from the consumer. HIPAA, that, because of the world we live in, health data goes way beyond just what is required for actual medical treatment. So going in and seeing your doctor for a fever or for surgery is, at least in the United States, that is covered by HIPAA. That is specific healthcare data. And GDPR covers everything, and health data is a subset of that as a sensitive data. So what is happening in the United States is other states like Washington and parts of these new privacy laws follow GDPR's lead to a certain extent and bring health data under that sensitive data umbrella, which has heightened security and notice requirements, but also the Washington law that goes into effect, I think, in a year and a half or so, but that one covers every aspect of health data. That is wellness data, that is data you give your chiropractor, that's data you give the yoga studio that has to do with your health. And this, I think, is a knock on the door for companies, including your health trackers. MyFitnessPal is a prime example of health data that's collected without real clarity or notice of what is actually being tracked, taken, used, analyzed, and resold. The FTC has started to crack down on that. The health data breach rule was resurrected. It's been around since 2009, but it was recently used against two different companies. GoodRx was the first example. And the importance there is that, at least in my opinion, the FTC took the definition of breach and blew it out into an unauthorized use or undisclosed use, rather than just an unauthorized taking or access by a hacker or someone who shouldn't have had access to that data. This was a known use by the company, but they were using it for an undisclosed use to their consumers, and that was considered a breach under the health under that health rule under the FTC's GoodRx. And I think that that aspect of broadening the scope of what is considered an unauthorized use of personal data, health data in particular, is going to have a lot of repercussions. And I think that is going to be mirrored in a lot of the state laws and how they pursue an unauthorized use of sensitive health data. And that, I think, covers, for instance, I don't know how this is going on in Europe, but in the United States, there is a boom in like wellness provision, like IV drips that aren't through a doctor's office, hot sauna or compression therapy, medi spas who offer Botox, but then all sorts of laser, all sorts of peripheral things that aren't healthcare, but they are health adjacent, is what I call them, because they are collecting sensitive information about things that are done to your wellness, that are done to your physicality, your mental state. All of these things are health adjacent, and that data is being collected more and more and more. Your heart rate, your eye movement, your voice tone, your voice tracking, all of that has to play into your mental state, your health. And those things are becoming, along with children's data, they're on the radar of regulators. They're on the radar of state legislators. But more and more, the consumers in the US at least, and I think Europe has been there for a while, particularly in the UK, but when it comes to health data, we're starting to realize that as consumers, stuff is taken from us all the time, and we willfully, willingly, and unknowingly provide it. And then companies take it and do a number of things that they're not supposed to do with that. And I think insurance carriers, health carriers are prime for this type of regulation, because there's a lot of leeway in HIPAA for using that health data or information surrounding your health to send advertisements out and work with third parties. It's a very gray area. There's a lot of hedging done by insurance companies as far as what they do and where they share your data. So I think that area, you'll see the crossover between HIPAA and the allowance. And I see insurance companies arguing that HIPAA covers that use rather than the state privacy laws, because the state privacy laws are going to exact, and the FTC rule will exact a lot, I think, a much greater cost against those insurance companies for using our data to market and sell to third parties and partner with third parties and derive value. Even if it isn't monetary, they're deriving value from that. And that's most of the state privacy laws here. They exempt HIPAA, but there's a lot of health and wellness data that is collected adjacent to true medical care. So I, from a legal standpoint, this area of the law definitely needs good product designers, good engineers, people who have taken the time to sit down and learn about what the guidelines are. And in my opinion too, if I would always advise my teams, if you would feel uncomfortable giving this stuff out about yourself, your significant others, your parents, your kids, then maybe we shouldn't be collecting it. Maybe these are things that people need explicit notice about. Maybe these are things that we should pseudonymize or anonymize and not collect. Like if it makes you uncomfortable as somebody designing this, if it would apply to you, then perhaps that's the first trigger to reaching out to your CISO, your legal counsel, whoever it might be, and see if it feels icky, it probably is not right under the law. So and I think that's a very non-legal definition, but the ick factor was always a good barometer for the product, the dev team, the architects that I worked with. They, if it felt icky, then I usually got an email, and they were usually spot on.
That's great advice. And as an engineer, we love when lawyers can make those principles so easy to understand. So that's that's a very good way to.
The ick factor, it worked. And it's amazing, just a little bit of education with a team.
Right.
That's why I think not necessarily every attorney, but I think some attorneys with the practical understanding of what the process is as embeds with those teams, even for just a day, the education that happens, and because engineers are smart, and they want to know what to do. And if you can just give them a few, not boxes to check, but a few guidelines that can move with the projects, it seemed to be very, very helpful, and a little education went a long, long way.
Absolutely. Thank you very much for these remarks, Jenifer. We will be coming back to this relationship with authors of software and with engineers. Berrin, can you share with us the perspective that working on your company's technology has developed, has given you into this issue and its challenges?
Yes, thank you very much, everyone. Thank you, and I'm honored to be invited to IEEE's panel. So thank you all for inviting me. I come from medicine, and specifically from public health. And public health is an interesting area that deals with privacy, because it can be the common good, as we've seen with the COVID pandemic, versus the individual's preferences and rights. So we founded called Privacy Labs. This is a technology company, and the vision has been integrating and sharing an individual's information has to be done in a privacy conscious manner, with the individual at the center and on control of their information at all times. So when we talk about health and health-related data, I see, and some of these things have been discussed here, but by the other panelists, there are different ways privacy deals with health data, or health data are classified. In US, HIPAA deals with data that's created in a clinical setting. So if the data is created in a medical, by the provider's office, this could be clinical encounters, records, medical data, lab data, claims data, they are protected by HIPAA, mainly for exchanging for treatment, operations, and benefits payments. Now, there are in US other medical data that have higher sensitivity, that are protected by additional laws. These can be federal laws, or these can be state laws. One example is substance use disorder data. Anytime an individual, a record or something data can link an individual to having received or is receiving substance use disorder treatment, or linking that individual to this type of problem, that data is highly sensitive, and it requires a very granular consent from the individual before it can be exchanged with anybody, even if it's a medical provider. The individual has to provide a consent saying, this doctor at this hospital can see this part of my data for this purpose, for this duration. This is to protect the individual from discrimination, from other problems, also to help them to actually come forward and receive treatment. But this also brings some problems. Many times this type of data is not exchanged freely. Mental health, again, is some problem that, some issue that can have protections with different states at different levels. Other sensitive data are data related to reproductive health, genetic information. So these can have additional protections and require many times consent to be even exchanged with partners. And then there is the patient-generated data. And I'm interested to hear about the state of Washington's new law, because patient-generated data in US, as far as I know, is not protected under HIPAA, is not part of HIPAA. These are any information that we use for exercising, for Fitbit, for recording our sleep patterns, wellness, mental health, all these apps, we willingly provide this information and they are not really protected. And then there's the idea of other health-related data, which we will, I think, hear more often in the coming years. These are the data types that traditionally have not been included in medical care. This is the information, our social lives, our environmental exposures, occupational exposures, where we are. So social determinants of health are a general concept part of this type of information. And they're described as, this is the data that describes where people are born, live, work, play, because we know now this type of information directly impacts health risks and health outcomes. So this is one of the goals of the health department here, to integrate into medical records so that providers can also see this type of information about individuals. But there are problems with integrating. Some of them are technical problems. Some of them are like interoperability problems, because all these different systems use different types, different standards. Even if they use same standard, they implement it differently. And another big part of not being able to share is the privacy concerns. And a new concept is emerging, that data privacy itself is also becoming a social determinant of health for many different reasons, like when these apps share information, when different companies create profiles and provide personalized, targeted advertisements to people. Again, that impacts with public health efforts and also links to outcomes. And I will just briefly mention, try to do it briefly, of some of these examples. Here's a picture from a story that New York Times ran a while ago. And this is about how our cell phones broadcast our geographic location throughout the day, especially if you don't turn it off. They do it multiple times. Many times people aren't aware. But what New York Times journalists did was, just based on this type of information, they could actually identify who some of these people were. There was a teacher, there were very specific things that people do throughout the day. At certain times they visit this clinic, they go to this, they spend time here, there. So this private information is available for sale to third parties, again, for use for different purposes. Some of the apps collect very personalized medical information, which is linked to our health, like women use their period tracking apps, enter some very sensitive information about their periods, which again may be sold to third parties. Mental health apps. There have been some papers looking at these, and that the privacy protections weren't really very good. Many times companies weren't even aware of what they have to do, how they have to protect, and to request consent. So this is an example of too much data sharing. But then there is also the concept of little data sharing that impacts people. And sometimes privacy is a problem there. Like I mentioned, substance use disorder data. Here's another example. This is from 2022. A woman's death linked to not being able to share. And there are many problems, interoperability, technical problems, which we are also working with as a company, but also some of the concerns from different agencies, different organizations, is the concerns about privacy. So critical data can sometimes be stranded in different systems. And when the doctors have to see this type of information, they don't get access, that can also be a problem. And just briefly, what we are working on is, it's called Privacy Labs. We have an interoperability platform, and it has mainly two components. One, helping organizations ingest and harmonize these data coming from all different sources with different standards, different units. It can work with graph or relational databases, standard agnostic. And the other feature is a consent management system. And the reason we actually came up with this and worked on this was these specific problems about the very sensitive data not being able to be filtered while organizations exchange it with their partners. So this is a consent management system helping companies or organizations capture consent, but also integrate these preferences to filter data as they are exchanging with their partners. And in US, many times a concern is organizations, health systems want to keep their sensitive data within their system, so we don't gather this type of data and do it without having the data. I talked fast, but this is basically what I wanted to mention. So in terms of public health, there are features where an individual's right have to be at the center, having control over their information. But then there is also the common good where public health data is needed for research, where we have to think about how we can improve the population health. And these are very, very interrelated topics. And thank you. And, I'll be happy to discuss further.
Thanks, Berrin, for the interesting overview of technical aspects related to privacy of healthcare data. And I would like to remind the participants that are already sending good points to us, while I can see also the chat, if you can share your questions and comments in the Q&A so that we can have a queue of those for our discussion. In the meantime, I would like to go back to Agata, and this is actually a question that I think may be extended to also the other panelists later. But how do you? So we are IEEE, and our objective is to advance technology for humanity, so to help. So how can we help? How can we contribute to, as you outlined in your initial statement, empower the individuals to take control of their digital privacy in these digital health space that we are building all together?
Thank you. So I will start maybe taking something from what my fellow panelists said. And I think what was highlighted now in both the presentation, their presentation, is that like the data that are used now in the digital health space go way beyond the traditional biomedical data. So healthcare is going above and beyond what was the traditional sector spaces dedicated to healthcare, which means that we have to pay attention to those data that are not strictly biomedical. And yet when these are put together, they're crafted, analyzed by maybe machine learning, artificial intelligence, right? They can reveal very relevant information about individuals. For example, we can make assessment and anticipation about the health status of a person, of an individual, or even at a population level of groups. And so I think, first of all, IEEE should bring up among their the people that are part of IEEE, so engineers and experts, this idea and knowledge, promoting ethical understanding and ethical thinking, let's say, about all the issues that might emerge from the use and analysis of these different data. And so we cannot think that because we deal with, as was shown by Berrin just a minute ago, we deal with location data, well, those are not relevant for health, because actually, if these are put together with few other information, we can actually quite precisely pinpoint somebody to some sort of health issues, for example, mental health or others, right? And so I think it's really important to foster ethical knowledge within the engineering community, and highlighting that there are solution seminar training that can be taken by experts also in this field. Secondly, I think, though, that it's really important to increase digital literacy from the or towards the public and the users, individual users of technologies, as they are those that in the end have to decide whether or not to agree to certain data uses. So I would really highlight that what I think European Union tried to do with GDPR in comparison, for example, to HIPAA, is to move away from this specification of health data only, or sensitive data, as for example, sensitive data might vary depending of where we are in the world. So different communities in the world consider sensitive different aspects of their health, and so I think the concept of sensitive data is could be very narrowly intended. And instead, I think the idea of personal identifiable data is quite interesting because goes beyond the data itself, but mainly focuses on the uses of data. So being very transparent, once again, towards which are the uses that we're making of the data, so that the individuals that, of course, must be trained in terms of digital literacy, trained in terms of how or what does it mean to share data, what does it mean that their own data are accessed, for example, by apps on their phones, right, can make informed decisions and choose whether or not be part of these systems or not. So I think there are different levels. And again, the aspect of transparency and communicating clearly to the public about the intended uses is absolutely fundamental.
In some ways, this sounds like the informed consent that is already the basis of medical practice, not just in privacy, but in actual medical care. So I think that this would resonate with both the health care professionals and the engineers as well. So that's a great point.
The only thing, if I could add, is not to transform the informed consent in a ticking boxing practice, which is, I think, a bit what is happening in the past years, right? Like to intended informed consent as a compliance mechanism. The idea is to inform the user. We want users that use good technology, that is actually effective and help people, they help taking care of their health, but cannot be reduced to just simply a ticking boxes exercise that is not actually informed consent.
Absolutely. And in fact, we have a question from Zafat that is basically complaining. That's a complaint that I hear not just in the digital healthcare space, but in all spaces, that we go to a doctor's office, for instance, we sign off privacy documents, consent that is supposedly informed, but as Agata was pointing out, sometimes it turns into a box ticking exercise. But then after doing this, we receive communications that seem oddly targeted to either the specific illness that we went there for, or more generally to the type of practice we went through, with some communication on key illnesses that are related to that practice. So and I think that maybe the most significant panelist to ask this to is Jenifer, but anyone is welcome to jump in also. Where is he asks, where is the leak? Where is the point where this supposed chain of consent and regulations and so on actually opens up to these marketing practices that are, they may be not illegal probably, but they are, of course, bothering the people that have signed off on privacy for very specific things.
They're becoming illegal. They are. There's, I think, under the regulations issued from Colorado and also California, that any use of sensitive data, and if it's not, HIPAA covered data, any use of that sensitive data, you have to have informed consent around that data, particularly for marketing. And I think the Washington, I haven't read the Washington law in total, but I do think that there's very stringent restrictions on using that type of data for any type of marketing. This is in particular, in my opinion, where engineers and your development team, the people who are setting up those API calls between the company, let's say it's your chiropractor collecting this information and they have a Facebook account that they've paid a certain amount to do marketing online for on Instagram. That API call will pull all sorts of data that you've provided. And that's what happened with GoodRx, is there was health data leaking through that mechanism and when you don't know what's being pulled, when you don't know how that software is working, you don't know what's being lost. And certainly a chiropractor's office is not going to know or have a development team to go look at that. They're just going to buy the marketing tool and use it. And if you're GoodRx and you have a massive marketing team, I'm 99.9% sure that marketing team never sat down with their data team or their legal counsel and actually looked and considered what might be being pulled into those social media platforms to do the marketing that they had signed up for. We assume, and I think we have assumed globally for a long time, that the technology is being built with some sort of ethics ingrained into it. And we are learning today that that is not happening, even in health. There are some companies who I do think do the right thing or do the ethical and legal thing, but there are several who I don't think it's necessarily intentional, but they are too busy trying to make money and become acquired and sell and crank through numbers to really consider what the consequences are for their users. And I saw a comment about security around it, and I agree too. And I think Agatha's right, is like there's a heightened sense around the security, and there's a heightened need for that, because without the data being secure, all your privacy work kind of flies out the window if everything's open and anybody can get to it anyway. And certainly the people who know how to find those openings are always on the hunt. And it's not, I think as tech has advanced and as we have integrated into every single aspect of our life, as an entire population, we've assumed certain rules surround the creation of the software, the creation of the platforms, and they don't. They have started to become part of this, and I know there's ethical guidelines in engineering, just like there's ethical guidelines in legal practice. But when you are being hammered by the board to meet a deadline, and you have certain, benchmarks that you have to meet, there's certain things fall through the cracks and certain things don't get addressed because they're not necessarily important for revenue. They're not important for board approval. They're not important for funding. And those things to this point have been the consumer's rights that I think have fallen through the cracks. So the best analogy that I've found because all of this data lives in a place where we don't have a physical reference for it as human beings. We don't have a physical reference for what's going through the software, where the software lives, the databases, the data farms, where all this information is kept. We don't have a physical reference for that. It's like in our office, we have a bookcase. That's where all the books are. We have file cabinets where the files used to be. That's a physical reference. We understand that as human beings, but everybody creating these companies, everybody using these platforms, there's no physical, mental awareness. There's no real understanding of where this data lives, what's being done with it, where we can go to access it, who we can ask for it. That is coming. We are getting there. GDPR was a big part of that, but everywhere in the world, well, most places, you have to build buildings to code. You can't build a skyscraper without meeting certain requirements, right? You can't put an elevator in without having it reviewed and checked and safety checked and meeting certain standards. You can't build certain buildings in certain parts of Japan without meeting certain earthquake requirements. Those are things that have been built in to provide safety for the human being. We don't have those same guidelines in the digital space on the internet. And the internet is a massive 1,000-lane highway that's been running at 300 miles per hour for what, 40, 50 years now. And there's been no real understanding of what that meant for us. And I think the laws, which are always behind the technology, are just now starting to catch up. We're just now, as a population, realizing all of this is going on behind the scenes. When I talk to my family about what all this means, and what it really means when you click on a link on Facebook, like somebody's making money off of that every single time. They make money every single time you type on the keyboard. There's reasons why they want you on those platforms, and the law is just now starting to catch up. In the United States, we just now have a few people at the federal level who truly understand what's going on in tech and can ask important, accurate, relevant questions when the CEO of TikTok shows up. So that's, as from a legal perspective, that's it. We're way behind. We're trying to catch up. I think the more people who are able to elect people who are knowledgeable and understand, or at least make the effort to try and understand some of this stuff, and the more as a population we understand that this affects us, and this is, what happens behind and in the software, we don't have the ability to change, but the companies do. So there need to be, and I live in Texas, for crying out loud. Like, I live in the most unregulated part of the world probably, but there has to be some guidelines, because we are being manipulated. We are being fed information continually. And when your medical condition follows you through an Amazon checkout, or follows you to a blog that you read, that is disturbing. That is like somebody following you from the grocery store to your home, to your doctor's office in a physical manner. It's just a scripted software, and it's surveillance. And when people shy away from calling it commercial surveillance, but that's exactly what it is. And when it comes to our health data, and particularly where I got involved and why I dove into this world, was because of my children's data being taken. And that's their kids. They have that. These codes. We don't have building codes for software. We don't have building codes for a platform. And these laws, I think, are our first stab at trying to do something about that. So
you touched upon a couple of items that are very relevant to us at IEEE. IEEE has a code of ethics that deals with some of the principles that you mentioned. One of our sister initiatives from a couple of years back, the cybersecurity initiative, there was an attempt to create at least, not really an entire equivalent of the building code, but some sort of equivalent to the building code for application development. Yeah. Because, as you said, that's something that as an engineer, I teach in a school that is very similar to Agata's school. We are engineering institutions. Our institutions, if we look at our colleagues from different engineering branches, we see that we are lacking in that area, in the area of having appropriate codes and standards that we can bind ourselves and our employers. You were making a very good point about the struggle between the engineer and the management or the company, between our ethical obligation and also our obligation as employees or as entrepreneurs to build something innovative. We also got a question in the chat, and I would like to turn that around to Berrin, that has experience directly in innovating in this space. Ivie, I hope that I pronounced your name well, asked if privacy laws, privacy regulations inhibit innovation in the healthcare space. if you in your development, of course, your company somehow answers these challenges. So maybe for you it is actually an a support. But generally speaking, is regulation in this space inhibiting innovation for you or for the customers that you serve, for instance?
This is an interesting question, and you're right. We are actually helping innovation to integrate privacy-conscious manner. So this has been argued a lot if privacy is limiting or empowering. And I want to mention with health data, when actually, before I answer that, I want to add that even when you ask consent to patients in many healthcare settings, and I don't know about Europe, but I suspect depending on countries, this is not too different. Health systems are even not there yet to have digital consent integrated into their system. What they do is paper-based consent. Many times consent is taken on a paper and then faxed to different places. And that's actually a problem by itself, because the problem is not just sharing too much information. The problem is not being able to share when the person needs the information to be shared. So it has two different aspects. Innovation is very behind in terms of healthcare, I think. Digital tech companies, health tech companies, and there are different reasons. You know, healthcare is by itself very slow in progressing with innovation, but the privacy is a excuse many times, I would say. It's not necessarily the problem, but it's the excuse that, oh, we cannot because we cannot share because privacy. One of the articles I mentioned about the woman's death in Alaska, there were many problems, but one of the issues was also the State Department wasn't exchanging data because citing privacy concerns. This is also a problem when different organizations, children's data. Nowadays, it's an important thing to provide educational data or nursing data from schools into health systems so that the pediatricians can see what is going on in the child's life. But that also has different protection levels, different laws, and also cited as a concern. So it's also not done efficiently. And our point is our technology mainly is developed to enable that they can actually integrate this consent and not just checkbox, but in a contextual manner. Context change. People may change their ideas. One provider today, he was good to see that data. Tomorrow may not be actually the appropriate person to see that information. So in a contextual manner, if organizations can integrate preferences as they share. So I don't think privacy should be a problem inhibiting innovation, but it is many times used as an excuse by different organizations who are way behind in technology. The other I want to mention is I keep making the distinction between health systems versus these private tech companies, apps, wellness apps, because there is a difference in business models. You mentioned GoodRx. I remember papers from years ago about GoodRx because their business model was, if I remember correctly, done in terms of sharing data. So, you find the cheapest medicine, but at the same time, you're providing information, you're self-entering this information about what type of medications you are using, linking you to certain health problems. Similarly, when we do certain Google searches, there's actually a paper from, I think it was published in British Medical Journal from a computer science department. I believe it was in Australia. They tracked these medicine apps, pharmaceutical apps. And what they found was these were shared with other partners of these companies, and they were sharing it with other fourth companies, and then further on. And at the end, it was coming to some large companies, Alphabet Inc. or others, and they have so much information about individuals, creating these profiles that they have not just about your diseases, your mental health, your religious affiliation, your sexual orientation, all these highly sensitive issues that is available. And one more final thing I want to say is, Jenifer, you have more knowledge on that, but many times when we agree to use an app, our agreement is within the app company, between us and that app company. we don't really have much to say with what the app company has agreements with other partners. So we don't get to say, it would be ideal to have users, consumers to say, your data will be used for this purposes, will be shared with this company for this purposes only, or you can choose what purposes. But many times our agreements are limited because we don't get to see what other partners they are there and what types of purposes they are using our information. So I think there are multiple levels of this privacy, and if you want to empower individuals, we have to know everything. And many times people also may not know. Like, it may not mean much for me if my information is exchanged with this company, because I don't know what that company is doing, or what their business model or goals are, or what this will be, if it will be changed in the future. So I think there are multiple levels of protecting an individual's privacy and empowering them.
Oregon, their most recent, it's just waiting on the governor's signature, but they had bipartisan, and for the United States, that's a big deal, bipartisan support for their privacy legislation that just got, I think it went through unanimously in the House, but it gives, it requires disclosure of that third party, not just who the third parties are, but what the uses are. And that goes far beyond anything else. That goes beyond HIPAA. And I think there's some saber rattling in DC, because HIPAA, the loopholes, I can't tell you, through my insurance, my personal insurance here in the United States, I get garbage all the time in my inbox about stuff that's not related to my healthcare. And that in my opinion is, as a legal privacy attorney, is a violation of HIPAA, because it has nothing to do with my healthcare. So you should not be using it, and I should not be getting emails about what was it, sleep apnea. I don't have that yet. So why am I getting it? And that is under HIPAA, but also even the Texas law, you have to get, according to these new privacy laws, you have to get consent to use that health data for advertising. And that is going to hit a lot of these companies, because healthcare is a big business in the United States. It's right. I think that's part of the issue.
Which is a significant difference with the European Union. It's also a significant difference to take into account for risk assessment, for instance, in cybersecurity. The healthcare data in the US has more value because it is also valuable, for instance, to insurance companies, which is a non-existent or very limited risk over here. Yeah. This last exchange among you two connects back to one of the questions we had earlier. We are getting close to the end of our slot. I just wanted to acknowledge Luis Kuhn, that wrote several super intelligent remarks in the Q&A box. I think they were targeted to our panelists, so I'm sure that our panelists took notice of that. We don't have time to go over them. I wanted to just give each of you, starting with Agata, a moment to maybe share one final closing thought, 1 minute, just to summarize a key point that you think has arisen out of our discussion today, which was super interesting. I really followed it with a lot of interest, and I hope that this was true also for our followers online. Agata, if you want to give a closing remark.
Thank you very much. Yeah, I think also from the Q&A points, what I would like to highlight is that, of course, security is super important. And I think the discussion about privacy that we had today was really to highlight that when we talk about privacy, we talk about many different things. Of course, security is there, and there is a lot of there must be a lot of effort in trying to make this system as robust as possible, and all this system robust to protect the specific type of data that they deal with. So there was a question about different data given the different users and the data that are collected, phone calls versus text messages or online data. Of course, that's absolutely important and absolutely an effort that we have to do. At the same time, privacy is way more. It's about engaging the people and making them and being transparent towards them, explain how the data are going to be used. First data uses, but also secondary uses, as were mentioned by Jenifer a moment ago, right? How next the other companies are gonna using the data. And so I think we have to consider all these aspects, which have way more ethical implications, of course, for potential discriminations, potential, marketing target that we don't need or required. And so absolutely all these different facets have been taken account. Absolutely.
Thank you very much, Agata. Jenifer, any final comments?
I did so much talking. I think just thank you for allowing us to talk and vet this among all of you, and for the invitation. Thanks.
Berrin, any closing remarks?
Thank you again. Also, thank you for being part of this, and anybody can reach me offline if you want to discuss further. My final thing would be, I think trust is a major issue. We cannot access anything, achieve any goals without trust, whether this is public health, whether this is medical or any app use. And for trust, we have to let individuals know and have them agree. That's all I want to say for, and thank you again, everybody.
Thank you very much, Agata, Jenifer, Berrin, thanks a lot. Your different perspectives were immensely valuable, and I learned a lot from the discussion today, which is the important thing. To the viewers, thank you for dedicating 1 hour out of your busy schedule to follow us today, or to listen to this recording if you are listening to it afterwards. I would just like to point out that the Future Tech Forum is being run by Future Directions, and you can connect to the address on the screen to learn more about it. For the Digital Privacy Initiative, please visit us at our website, digitalprivacy.ieee.org. You can send us an email with comments on this webinar, things that you would like to see in other webinars, or if you are an IEEE member, and even if you're not, and you want to volunteer to work on our committees and to contribute to shaping our content and outputs, please write us an email at digitalprivacyinfo@ieee.org. Thanks again to the panelists and to our viewers and to the wonderful staff that has been working behind the scenes to make this happen. This is all for our program today. Thank you very much.